Hi, drivers. Paul Taylor from Truckers Justice Center. I know all of you have some familiarity with the controlled substance and alcohol testing regulations of the Department of Transportation. And if you've been trucking for a while, more than a year, you visit any of the various Facebook discussion forums, you read information, you'll see people asserting that the DOT's controlled substance and alcohol testing regulations are unconstitutional. Now, most lay people who assert that something's unconstitutional probably haven't read the Constitution. So in fact, much as I might not like things the way they are, the United States Supreme Court has declared the DOT's controlled substance regulations, testing regulations, as constitutional. This goes way back. There was a big clamor back when I was dispatching and then when I was in law school for controlled substance and alcohol testing regulations by DOT in the various industries, including rail, motor, and air. And so the Reagan administration began putting together regulations for random testing, pre-employment, post-accident testing. Testing existed before that, but it was very limited. And in part was because there were strong labor union agreements that the labor unions, Teamsters, in trucking anyway, and the railroad workers unions, under their collective bargaining agreements, there was strong resistance to controlled substance, mandatory controlled substance and alcohol testing regulations. But due to various circumstances, there was a push. And during the Reagan administration, a guy named Sam Skinner was Ronald Reagan's last transportation secretary. They promulgated regulations that have changed some, but look a lot like what we have today, 30 plus years later. And those regulations were challenged in court. And it went all the way to the Supreme Court in a case called Skinner versus Railway Labor Executives. And that was a constitutional challenge to the DOT's regulations relating to railroaders. And it's basically the same regulations we have today for trucking. DOT for trucking, Federal Motor Carrier Safety Administration, has certain regulations that are unique to trucking, but the things that are not unique to trucking, that apply to pilots, aircraft mechanics, flight attendants, truck drivers, railroad workers, conductors on railroads, engineers on railroads, those are embodied at 49 CFR Part 40, which you all should be familiar with, because these are violations of those regulations by you as your death warrant to your career. So those regulations, similar to what we have today, were challenged in court by the Railway Labor Executives Association. And it went to the U.S. Supreme Court. And the issues at the Supreme Court were, one, is this a test that is subject to constitutional scrutiny? In other words, are these a search within the meaning of the Fourth Amendment to the Constitution? And two, is it a search that requires a warrant, or is it a warrantless search if in fact it's a search within the meaning of the Constitution? And three, are there exceptions if this is a search that requires a warrant, which it didn't. So in a constitutional challenge, the first issue at the Supreme Court was, one, is this a search? And the industry, management of railroad, and motor carriers were involved because it was the same regulations, but the industry filed what are called amicus brief, friends of the court brief, with the Supreme Court. And the Supreme Court unanimously on this part of the decision said, this is a search within the meaning of the Constitution, the Fourth Amendment to the Constitution, which prohibits unreasonable searches and seizures, and a warrant shall not issue without probable cause. That's essentially that part, the search part of the Fourth Amendment to the Constitution. And the trucking industry and the rail industry said, well, this isn't a government search subject to to be challenged under the Constitution because there's no state action. Okay, essentially, the Constitution doesn't apply normally to private parties. Your boss, absent a statute, can search your locker at work, or they can search your truck for other things. But at least without violating the Fourth Amendment. Could violate some other amendment or some other provision of law, but the Fourth Amendment search and seizure, unreasonable search and seizure prohibition applies to government search and which requires state action. And although the rail industry and the trucking industry said there's no state action here because it's private companies doing it, that might be true if they weren't mandated. If it was an insurance company mandating or the company doing it on its own. But the Supreme Court, the majority, in fact, I believe it was unanimous on this issue alone, said there's state action here, and thus the Fourth Amendment applies. Sounds great, right, drivers? Well, no, we don't get to that point where they're just prohibited because it's state action. The Constitution prohibits unreasonable searches and seizures. And the Supreme Court, in a dance, in my view, in a 7-2 opinion, said, well, evidence shows that drug use, alcohol use are a problem in the rail industry. Remember, this was a rail case. But, there were same issues raised when it came to trucking. But there's a problem with use of drugs, and when you're out there, you have a diminished expectation of privacy at work, and people are working in the stream of commerce. And essentially, there were lower court cases dealing with motor carriers only that follow the same thing. That essentially, you truck drivers, the Supreme Court has held that people working in these transportation industries, I think the effect is that you check your constitutional rights at the door. Because there's a problem in industries with drug use, therefore you cede some of your constitutional rights. I don't like it, but that's the way it's shaped up. They've said, the Supreme Court has said, one, yes, this is a Fourth Amendment issue. It is a search within the meaning of the Fourth Amendment, but they don't require probable cause, reasonable suspicion, all those things that apply to private citizens when it comes to state action like police and things of that nature. That you have a diminished constitutional protections because you work in an industry that's highly regulated and in the stream of commerce. And what was interesting about this Supreme Court decision, that part of the decision upholding the regulations as constitutional, it was a 7-2 vote. All members who were on that panel are now gone. They're not dead. Justice Kennedy is still alive, but they're all off the Supreme Court. But it's a 7-2 decision. The two were Thurgood Marshall, a liberal giant civil libertarian, and William Brennan, another civil libertarian. And they said, well, it may be that the controlled substance and alcohol testing regulations which apply these searches are good. It makes life safer on the highways. But they said, we don't. These people working in these regulated transportation industries do not check their rights at the door. They don't give up their constitutional rights because they are truck drivers or railroad workers or whatever. And, they said that's the price we pay for a free society. But they were the dissenters. Will this ever come up again in the courts? I doubt it, but I thought you might want to know how this constitutionality of these regulations were figured out. Thanks for watching.